Hello everyone and welcome to this UCL Faculty of Laws webinar. My name is Alex Mills. I'm Professor of Public and Private International Law at UCL and I'll be the chair for this event. Before we begin, I just want to say thank you to the UCL events team, especially Lisa Penfold and Kat Balogan for their terrific support in putting on this event. And I also want to acknowledge that most of the work of organizing this event was done by Nico Pavlopoulos, one of our speakers this evening, who's a PhD candidate in the Faculty of Laws. In fact, I can happily say he's a recently submitted PhD candidate in the Faculty of Laws. So we have an extremely interesting topic and a terrific panel lined up for you, and I'm looking forward very much to hearing what they all have to say, so I'll try not to speak for too long, although I will say a few words by way of introduction. We have four speakers: Peter Webster, Dr. Federica Pedeo, Nico Pavlopoulos, and Professor Tom Ruys, and I'll introduce each of them briefly before they speak. They will each speak for about 12 minutes, and then there should be plenty of time for discussion and Q&A. You can submit questions to the panel in writing using the Q&A facility, which should appear somewhere on the bottom of your screen. We may not have time to respond to all your questions, but please do ask them and we'll do our best. So we're here to talk about the problems raised as a matter of English law and international law, where the government of a state is contested. And this can arise in a number of circumstances. Perhaps classically, we might think of a foreign state under civil war, with different groups competing for control, as in Libya or Syria. But the situation may equally arise within a constitutional framework. It doesn't take much imagination, for example, to think of a scenario in which a leader with autocratic tendencies loses an election, but refuses to accept the results, claiming perhaps that there was widespread fraud in postal voting, and tries to cling on to power through a series of increasingly desperate lawsuits, tweets, and press conferences in landscaping centers. Such hypotheticals aside, the context which triggers our discussion today is Venezuela, where there has been a dispute for the last 2 years since controversial 2018 elections over who is the president, a position which is potentially both head of state and head of government. On the one hand, we have Nicolás Maduro, the incumbent and the successor to Hugo Chavez, who has the support of the Venezuelan Constitutional Court. And on the other hand, we have Juan Guaidó, who has the support of the National Assembly. Both claim to be the legitimate president under the Venezuelan Constitution. As we will hear, the world has divided in its reaction to this situation. Some states clearly on one side, some states clearly on the other, and some states muddling along somewhere in the middle. But the very particular context which triggers our discussion today is a decision of the England and Wales Court of Appeal last month between two rival boards of the Central Bank of Venezuela appointed by the rival presidents. The case concerns the Venezuelan Central Bank's national gold reserves held in the Bank of England, which are worth about £1.5 billion. The question, in a nutshell, is which board has authority to give instructions regarding these gold reserves. And this potentially raises questions of both English law, particularly the significance of UK government statements, as well as international law. So our panel is going to start with a focus on this dispute, but then use it as a launching pad to address wider issues around disputed governments in international law. So the panelists will address not just who is the president of Venezuela, but more generally, how should states decide who is entitled to act on behalf of another state? And does there have to be one answer, or can there be different answers for different purposes, as we will see the English courts have suggested? And what are the consequences in international law if a state gets this wrong, if they recognize the wrong party as the government? The issue of contested governments is about much more than approximately 31 tons of Venezuelan gold, although that is significant enough, particularly for the Bank of England itself and its reputation as a safe place for foreign governments to store gold. It can affect a variety of other questions, like who has the right to appoint diplomats, who has the right to represent the state in international organizations, perhaps even who could invite foreign states to send troops to help them gain effective control over their territory. And if different states recognize different governments and send troops to support them, a disputed election can therefore potentially escalate into an international armed conflict. So there is indeed a lot at stake in these questions. So without further ado, I now have the honor of introducing our first speaker, Peter Webster, who is a barrister at Essex Court Chambers. He has a PhD from Edinburgh University and a lot of experience in litigating international law questions before the English courts and international tribunals. Peter is going to focus on the approach of the English courts in the Venezuelan gold litigation itself, what the Court of Appeal decided and what it didn't decide. And I'm delighted to invite him to address us now.
Thanks very much, Alex, and thanks to you and your colleagues for the invitation to speak this evening. There are very many fascinating aspects of the Court of Appeal's judgment, and I would like to use this evening's seminar as an opportunity to offer some reflections on just one of them. Namely, if the UK has recognised one regime de jure and another de facto, which, if either of those two regimes, is entitled to the property situated in England. Before turning to those comments, though, it's helpful to remind ourselves of some key points of the decision. In summary, at first instance, Mr. Justice Tier held that the UK government had recognised Mr. Guaidó as President of Venezuela, and that was conclusive before an English court. Significantly, he held that it was necessarily implicit in the recognition of Guaidó as interim president that Mr. Maduro was not recognised. There could, he said, not be two presidents of Venezuela. So, the outcome at first instance was that Mr. Guaidó was recognised, and that was determinative. The Court of Appeal allowed the Maduro board's appeal. The key point on which it differed from the High Court is that recognition of Mr. Guaidó as the person entitled to be interim president does not mean that the UK cannot also recognise Mr. Maduro as, in fact, acting as president. To reach this conclusion, the Court of Appeal identified that the terms de jure government and de facto government are used in two different ways in the English case law. On one approach to the terminology, both types of government have effective control of the relevant foreign territory. Recognition of a de jure government is the fullest type of recognition, whereas recognition as a de facto government recognises that the government is exercising effective control, but admits some doubts, perhaps, about whether that will remain firmly established. On that approach, of course, the UK cannot simultaneously recognise a different de jure and de facto regime. But a second meaning is different. On this approach, a de jure government is one which ought to possess the powers of sovereignty, though it may at the time have been deprived of them, whereas a de facto government is one which really is in possession of them, although that possession may be wrongful or precarious. On that approach to the terminology, called the Luther and Seger approach, for that's the case in which that definition was set down, the UK can recognise both a de facto government and a de jure government in respect of the same territory at the same time. What matters, therefore, is working out what type of recognition actually has been bestowed. Or, as Churchill put it, writing to Roosevelt in 1943, what does recognition mean? One can recognise a man as an emperor or as a grocer. Recognition is meaningless without a defining formula. The critical issue for the Court of Appeal, therefore, was to work out the meaning of the UK government's statement in respect of Mr. Guaidó's position. And it interpreted the UK government's statement as recognising Guaidó as de jure interim president, namely the person entitled to that position. But departing from the court below, the Court of Appeal held that recognising Guaidó as de jure interim president did not prevent the UK from also recognising Maduro as de facto president, i.e. the person in effective control. The fact that the UK had continued diplomatic relations with the Maduro regime was a particularly significant factor. And the fact that the UK government's statement recognising Guaidó was not recognition in the fullest sense of the word leaves open the possibility that the UK recognises Maduro as the de facto president, and so the Court of Appeal ordered further court proceedings to determine that point. Against that background, let me now turn to the point on which I want to focus this evening. Where there is a different de facto and de jure regime recognised by the UK, which, if either of those two regimes, is entitled to the state property situated in England. The Court of Appeal reasoned as follows. First, it identified a broad general rule. It stated that where one government is recognized de facto, English law is clear that the acts of a rival government must be treated as a nullity, even if that rival government is recognized de jure. However, having identified that broad general principle, it then identified a limited exception in respect of the state's property situated in England. That was based on the High Court decision in Haile Selassie and Cable and Wireless from 1939. On the Court of Appeal's approach, however, this exception is of very limited scope, if indeed it exists at all. In Haile Selassie, money was due under a contract that had been concluded between the defendant and the Ethiopian Director General of Posts, Telegraphs and Telephones. The contract had been concluded before the 1935 Italian invasion. There was no doubt that money was due under it, and that debt was a chose in action recoverable in England. By the time, though, that proceedings were brought by the emperor, the Italian regime was recognized as the de facto government, albeit that the emperor was still recognized de jure. Mr. Justice Bennett held that recognition of a new de facto government did not deprive Emperor Haile Selassie of title to that debt because it was an asset in England. So long as he remained recognized as a de jure sovereign, he was able to sue under it. In the Venezuelan case, the Court of Appeal held that even if the Haile Selassie decision was correct, it did not apply on the facts here. That was because the Guaidó board's claims to have been appointed as the board of the Venezuelan Central Bank depend on certain pieces of Venezuelan legislation and also appointments made by Mr. Guaidó, and those acts all took place in Venezuela. And so the Court of Appeal said they were subject to the general rule, not to the exception recognized in Haile Selassie. I want to offer some comments on this approach, and donning, if I may, my practitioner hat, I want to offer some comments from both sides, the perspectives of both types of regime, without necessarily committing myself to any concluded view. First, looking at things from the perspective of the de jure regime. One can ask, I think, whether the Court of Appeal's formulation of the starting point is correct. Its starting point, of course, was this absolute one, that where one ruler or government is recognized de facto, its acts receive effect, and the acts of a rival government must be treated by English courts as a nullity. The two cases on which it relied as authority for that approach are Bank of Ethiopia and National Bank of Egypt, and Banco de Bilbao and Sancha. But in Haile Selassie, when Mr. Justice Bennett summarized the law arising from those cases, his formulation of the principle was, I think, much narrower than the Court of Appeal's general statement. His summary was not that generally all acts of the de facto regime must be treated as valid and all acts of the de jure regime treated as invalid. Rather, what he said was that English courts will recognize and give effect to the acts of the de facto government in relation to persons and property in the governed territory. And they will disregard and treat as a nullity the acts of the de jure government in that respect. So one can see an argument from the de jure government's perspective that what that is referring to is the situation in which English courts are considering the effect of legislative or governmental act on the status or rights of private persons or property in the foreign state who are subject to its effective control. That, it might be argued, is a different question to the question of what rights the state itself or its organs have in respect of property abroad. Second, one might say that the Court of Appeal's general approach does not sufficiently take into account the limitations which are inherent in recognizing one regime as a de facto regime when there is another, which is a de jure regime. As it was put in Luther and Sager, when the UK recognizes a regime as a de facto government, it's recognized as being in effective control, but that possession might be wrongful or temporary. It's inherent in the idea that another regime is recognized as de jure, that another regime has a preferable legal entitlement, albeit at the moment it can't make that effective. One might think that in such a situation, English law would be reluctant to recognize the claim of the de facto regime to very substantial assets, because allowing that claim would be permanently to make over those assets to a regime when the approach of English law is to say that another regime has a preferable legal entitlement. A third point that the de jure regime might make is to draw a parallel between its situation and that of a government in exile. Such a government is recognized de jure, but by definition is not in de facto control. And as Professor Tellman's study shows, various states have accepted that such a government can access the state's property abroad. Turning things on their head, however, and looking at matters from the de facto regime's viewpoint, if the right starting point is that acts of a de facto regime are valid, why should an exception be made in the circumstances of a case such as Haile Selassie? The approach there was that there was a de jure government which had no effective control in the relevant state, yet it was held entitled to recover the debt. Why, one might ask, should such a regime be entitled to the assets of a state simply because it can access them abroad without needing to perform any legal act in the territory of the foreign state? It's not in effective control of the state. There's no guarantee that it will ever assume effective control. And ultimately, the people who are subject, who are in the territory in respect of which we're talking about, are the people for whose benefit these assets ultimately are held. The court's reasoning in Haile Selassie was in part that the relevant assets were the sovereigns, and it's no concern of English law what the sovereign entitled to the assets does with them. One might, I think, now doubt whether that reasoning is forceful now, where there is a competing regime with established effective control. One final point that the de facto regime might make is that given the test in international law for recognition of a government is whether the government is in effective control of the state, see the Tinoco Award, what basis is there for England or the UK withholding that state's assets, or even worse, allowing another regime to access them, because of a view that the UK has formed that this other regime has a better legal claim to be entitled to exercise that effective control? So to wrap up, where there is both a de facto and a de jure regime in respect of the same territory, the precise circumstances in which each of those regimes is entitled to claim property in England is, I think, not as determined by the Court of Appeal's decision as one might think on a first read of it. Thank you very much for your attention.
Thank you very much, Peter. Terrific. For our second speaker, I'm delighted to welcome Dr. Federica Pedeo, who's the Derek Bowett Fellow in Law at Queen's College, Cambridge, and a Fellow of the Ladderpack Center for International Law. She has a law degree from Venezuela, as well as an LLM and PhD from Cambridge, and she works in a range of areas of international law with a particular expertise in questions of state responsibility. Federica is today going to put the English court's case in broader context by looking at the way that other states have responded to the situation in Venezuela. Federica, the virtual microphone is yours.
Thanks, Alex, and also many thanks to Kat and Nico for putting this together, and to the UCL events team for making it happen and for hosting this event. So as Alex said, what I thought I would do is provide a broader perspective or provide some context to the dispute that is currently pending in the English courts. I will provide an overview of the reactions of other states to Guaidó's claim to the Venezuelan presidency, and I will be using as the key themes, the two background issues that Peter mentioned as part of his analysis. So the language of the recognition statements on the one hand, as well as the status of diplomatic relations between those recognizing states and Maduro or Guaidó, or Maduro and Guaidó. As we will see, no clear picture emerges from this practice in terms of the recognition of Juan Guaidó than does in the UK. Questions of recognition of government are often complicated, as Alex pointed out at the beginning, especially where there are competing claims to the government of a state. International law, at least in the last century, resolved these questions by reference to the principle of effectiveness, namely the government, for the purposes of international law, is the entity which has effective control over the territory. But in the last few decades, we have seen the emergence of a different practice, which would suggest that the government of a state is, or at least can be, that entity which possesses democratic legitimacy. And this is precisely the situation that we have here. We have a struggle between a government that claims to be effective, that of Maduro's, and a government that claims to be the democratic legitimate one, that of Guaidó. It may be too soon to tell what lessons we can draw from the Venezuelan situation for the law of recognition, and in particular for either of these two doctrines. The preliminary question in any such assessment, nevertheless, is to establish whether, as a matter of international law, either of the two rival entities have been recognized as the government of the state by other states. This is a question which, as Ian Brownlee put it, must be resolved by reference to the intention of the recognizing states. And it is this preliminary question that I will consider. The broader question, the legal question, and the debate between effectiveness and democratic legitimacy of who is the government for the purposes of international law will be considered by Niko later on. And the further question of what happens if the practice of one state diverges from the standards set by international law will be then considered by Tom. So I will not say anything about either of these two issues. Now, the intention of the recognizing state must be assessed by reference to, according to Stefan Talman, all the evidence available. Now, the starting point will be a statement of recognition issued by the recognizing state, but this includes many other factors. Of these, I will consider questions of diplomatic relations and the holding of diplomatic premises, but I will mention at the end other relevant factors that might be taken into account in this assessment. Let me start then with recognition statements. So the first place we will look in determining whether a state has recognized a government of another state is the statements made by those states. Wikipedia tells me that there are now some 60 states that have recognized in some form or another Guaidó, or issued statements of recognition or of support for him. This is just shy of a third of the states in the world, and the number has remained relatively stable since last year, give and take places like Bolivia, which has recently switched sides. The language of recognition statements is not always identical, and very often these days done via Twitter. So there were lots of tweets recognizing or showing support for Guaidó in the early days of January and February of 2019. There is no template for a recognition statement. So to understand the intention of the recognizing state, we need to take a close look at the language used in these statements, the Churchill quote that Peter Webster mentioned earlier, recognition as what? Now, the majority of states that have issued statements in respect of Juan Guaidó have expressly recognized him as interim president of Venezuela. States in this category include many Latin American states, as well as Albania, Australia, Canada, Georgia, Israel, Kosovo, and most prominently, perhaps the United States. Some EU states, like the Netherlands, for example, have issued similar statements, but for the most part, European states have issued statements of support of Juan Guaidó as interim president. They have fallen short of using the language of recognition in this regard. Now, this difference in language can be key as to the intention to recognize. Nevertheless, these statements are only a part of the evidence from which an intention to recognize is to be inferred. And so they need to be looked at in the context of the recognizing state's subsequent practice. And it is in this regard that the question of diplomatic relations becomes important, because as we will see, there is some dissonance between the very encouraging statements made on the one hand on behalf of Juan Guaidó and the practice of some of these states. So let me turn to diplomatic relations. I should say at the outset that the maintenance of diplomatic relations is both conceptually and practically distinct from the question of recognition of governments. This seems like an obvious thing to say, but in the literature critical of the institution of recognition of governments, it has often been remarked that recognition is not necessary because we can simply infer it from diplomatic relations. That is, states do not need to issue recognition statements because recognition is simply implicit in diplomatic relations. However, the maintenance of diplomatic relations is in fact distinct from the question of recognition because, for example, recognition is possible even in the absence of diplomatic relations, and the interruption of diplomatic relations does not entail the recognition of the government in question. So the existence and nature of diplomatic relation is not per se conclusive as to recognition, but it must form part of the evidence from which we can infer the intention of the recognizing government. And here things get a bit trickier. Juan Guaidó has appointed representatives in all states that have recognized him, but not all states have considered these appointments and the relations established with these individuals as diplomatic relations in the sense of the Vienna Convention on Diplomatic Relations. At one end of the spectrum, there are states that have recognized Guaidó's appointees as his personal representatives and not as representatives of the Venezuelan state. This is the case of the UK, as Peter mentioned earlier, as well as of Austria, Czechia, France, and a few other European states. In these states, the government has maintained diplomatic relations with Maduro, and indeed, the appointments made by Maduro continue to be recognized as diplomats and continue to hold the diplomatic premises of Venezuela in those territories. At the other end of the spectrum, there are states that have recognized Guaidó's envoys as representatives of Venezuela, given them diplomatic status, and even handed over diplomatic premises of the Venezuelan state. Now, not many states have followed this path, for indeed, in many cases, these have raised difficult questions and given rise to some instability. Let me give you two examples. First is the US. Trump recognized Guaidó's appointee as ambassador and requested that Maduro's appointees leave the country and hand over the diplomatic premises to Guaidó's team. On leaving, Maduro's appointees handed the keys of the embassy to activist groups who occupied the premises, preventing access to Guaidó's team. In response, Guaidó's supporters blocked all access to the building in protest. Eventually, as you can expect, some violence broke out and the Secret Services made 9 arrests. The US demanded that the activists leave the building, which they of course refused to do. Now this raised a legal conundrum for the US government. Could they enter the embassy to forcibly remove the activists? Under the VCDR, host states must respect the inviolability of the sending state's diplomatic premises. They must not enter those premises without the consent of the sending state. So the legality of any forcible removal of the activists turned on who was the government of Venezuela, as it is that entity that has the capacity to consent to the US entering the mission. If Maduro was a recognized president, then the US ought not to enter the premises. The activists were there with the consent of the recognized government, and forcibly removing them would violate the inviolability of the premises. If it was Guaidó's team instead, then the US could enter the premises. Counting with his consent, they would not be in breach of the VCDR if they entered to remove the activists. Ultimately, giving effect to the recognition given to Guaidó, the US raided the embassy to remove the activists and handed control of the building to Guaidó's ambassador, who still holds it. Now, similar situations have arisen in Costa Rica, where, as at the moment of speaking, I am told that Juan Guaidó's ambassador still holds the embassy, and in Brazil, where there was a to and fro between the two sides, and I think it's Maduro's side that still holds the embassy now. In Bolivia, as I mentioned earlier, the embassy has gone back and forth between Maduro and Guaidó, depending on which of the two sides was recognized by the incumbent Bolivian president. Only a few weeks ago, the embassy went back to Maduro after the new president of Bolivia de-recognized Guaidó and recognized Maduro again. So what this shows is that even though states have been willing to recognize Guaidó as interim president or give him support as such, the extent to which they have given effect to this support in practice is not entirely unanimous or not entirely clear. Now, I focused on statements and diplomatic relations, but of course the evidence from which the intention to recognize can be inferred goes beyond this. It can be seen in the practice of domestic courts. There have, for example, been questions as to the ability of foreign investors to enforce international awards in the US on Venezuelan-owned property, and as to the representation of Venezuelan state-owned companies in US proceedings. Other executive practice might also be relevant. The US, for instance, has given access to Guaidó to Venezuelan government funds held in the US and have given Guaidó control of Citgo, a Venezuelan oil company based in the US. It can also be seen in respect of treaty practice of other states. Thus, Guaidó's accession to the Inter-American Treaty of Mutual Assistance, which had been denounced by Chavez, was accepted by most other treaty parties. Now, for reasons of time, we've not gone into this, but we can of course discuss the issues later in the Q&A. Now, the resolution of these issues is fundamental for the stability of international relations. Indeed, in addition to the daily and practical uncertainty and difficulties that the situation causes for Venezuelan citizens living abroad, which often have no access to consular or diplomatic premises, or that have competed consuls and ambassadors that they must turn to, There are many issues of international law which turn on the question of who is the rightful government of Venezuela. For example, international representation of Venezuelan dispute settlement, a matter which has been before investment tribunals, already hinges on this question. Consent to foreign military intervention, as Alex mentioned earlier, and this is a matter which was seriously debated in 2019 following some suggestive statements made by US officials. Membership of and representation in international organizations. The Inter-American Development Bank, for instance, has recognized a Guaidó representative, and the OAS has accepted a credentials challenge from the Guaidó team, and therefore accepting Guaidó's ambassador as the representative of Venezuela in the OAS. It must also be said that they have subsequently withdrawn the notification of withdrawal from the OAS that Maduro had initially submitted, so there's a question as to the continued membership of Venezuela in the OAS. So there are lots of divergent and inconsistent practice from states, all of them, if I may paraphrase Luigi Pirandello, in search of a clear theory and a clear law of recognition to help us make sense of who is the government of Venezuela, a matter of which Nico will speak next. Thank you.
Fantastic. Thank you very much, Federica. So our third speaker today is Nico Pavlopoulos, who is, as I've mentioned before, a recently submitted PhD candidate at UCL, where his terrific thesis is on the topic of the identity of governments in international law. Nico has previous degrees from Southampton and UCL, and he's taught at UCL and also at Durham for the last couple of years. Nico is going to address the broader question of how international law helps us, or perhaps doesn't help us, to determine who is the president of Venezuela, and indeed who is the government of other states. And I do not think there's anyone more qualified to address this topic. Nico, the floor is yours.
Many thanks, Alex, and thanks also to Lisa and Kat for making the event possible, and to all of our wonderful speakers. I'm really delighted to be here in such excellent company. So we've already heard from Federica that states have responded in all sorts of ways to the rival claims of the presidency of Venezuela. We've heard a little bit about the UK approach as well. And it's also become apparent so far that the identity of the government of a state is crucial to a number of questions. So to my mind, this raises the question of, does international law provide a framework for identifying the government of a state? And that's the question on which I will focus today. And I want to do three things. So first, I want to consider in general terms the notion that there exist criteria in international law for identifying the government. Secondly, I want to discuss why in recent years we have had trouble in ascertaining what these criteria are, or why there's been debate about that at the very least. And finally, I want to offer a suggestion as to perhaps what these criteria might or appear to be as a matter of contemporary international law, and to consider that approach in the light of the situation in Venezuela. So to start with part one, which I think is uncontroversial and I don't think merits too much time, is the idea that a state can have, as a matter of international law, no more than one government. There is no real suggestion to the contrary, and indeed there's much evidence to suggest that a state can, as a matter of international law, have only one government. In other words, Guaidó cannot, as a matter of international law, be the president of Venezuela vis-a-vis the US, while Maduro being the president of Venezuela vis-a-vis Russia. That simply wouldn't work as a matter of international law, and states don't generally seem to hold that approach. So we see, for example, that when a state recognizes a government, it typically implicitly or explicitly de-recognizes any other government it had previously recognized as such. And indeed, we see also in the practice of states that it's generally accepted that to qualify as the government of a state is to satisfy certain objective criteria. And we see this again, for example, in the context of Venezuela, where the states that protested the acceptance by the Organization of American States of Guaidó as president did so on the basis that they didn't consider him to be the president, and that the OAS cannot recognize whomever it wants as such. And we've already heard a little bit about the idea that effective control has generally been accepted to be the main criterion in international law. So that sums up part one. So there seems to be, or to have been, general acceptance that there have existed criteria. Now to move to part two, while it's been long established that effective control is the main factor for identifying the government of the state, and we've heard support for that earlier today in the Tinoco arbitration, more recently in the Court of Appeals judgment, we've seen a nod to that in exit proceedings concerning Venezuela, and in a number of other cases, we've seen that approach as well. I think it's worth mentioning that doesn't seem to be the only criterion. So sometimes we do have to establish whether a government is a puppet government, something that doesn't come up very frequently in practice and which is not of direct relevance here. But just not to lose sight of the fact that there may be other questions in other contexts. More fundamentally and more relevant for present purposes is the suggestion or the possibility that effective control no longer suffices, or perhaps is no longer at all relevant to the assessment of governmental status. So especially since the 1990s, we've seen a number of governments that are generally accepted as such without retaining or without ever having had effective control. And indeed, in enjoying the status of government while there exists a rival claimant, which is an effective control. So perhaps the first example where there was consensus in this regard was Haiti in 1991, but we've since seen a number of other examples, including Cote d'Ivoire and Honduras in 2010, Gambia in 2016, and so on. And there are also cases where the identity of a state's government is contested, even when one clearly has effective control. And that, at least arguably, seems to encompass the situation in Venezuela. So Maduro is indeed generally in control of the territory and population of Venezuela, but it's still obviously far from clear that he is indeed the president. So in respect of each of these situations, democratic elections appear to be relevant, and they sometimes have said to be relevant. So if we take the examples I mentioned earlier of Haiti, Cote d'Ivoire, Honduras, and Gambia, each government that was accepted as such had won a democratic election, while the other claimant in question had either lost a democratic election or had not participated in a democratic election at all. Again, democratic legitimacy appears relevant too to the situation in Venezuela, where there's a widespread view that the election on the basis of which Maduro claims the presidency to not have been free and fair, and therefore not allowing him to claim to be the president on that basis. And indeed, Guaidó was declared the interim president by the democratically elected National Assembly with a view to holding fresh presidential elections, precisely because the elections weren't deemed to have been free and fair. So it seems so far so good in terms of democracy being relevant as a criterion for governmental status. But there are a large number of states possessed of governments which are not democratically elected. Whether we look to the Vatican City or the Kingdom of Saudi Arabia, we can see that also in a number of transitional and other governments in Africa, including Libya, Central African Republic, Sudan, and Egypt. So I don't want to go on any of these examples in particular detail, but just to note that there do exist governments which are undemocratic. Which leads to the question of maybe, or leads perhaps to the suggestion that democracy is sometimes relevant. So is it a matter of regional custom? That also seems difficult to square with the practice, because the practice is not confined to any one region. And indeed, we've seen different responses within the same state. So Gambia had a so-called bloodless coup in '94, and an undemocratic government became the government. And in 2016, the democratically elected government or president was accepted as such, despite never having had effective control. So at best, then, maybe we could say that democracy is relevant in terms of the basis of a preference where there are competing claims. So when there's one democratic government and where there's another undemocratic government. But even then, practice seems difficult to square with that suggestion. We do see practice where an undemocratic government is given preference over a democratic government. And again, I don't want to discuss examples in detail, but I'm happy to chat about them later. And these include Myanmar in 1990, Ukraine in 2014, albeit with a view to holding presidential elections. And maybe Belarus since 5th of November seems perhaps to be giving us some more state practice in that regard. So in addition to the potential difficulties of squaring the practice with a requirement of democratic legitimacy, there seems to be also something else troubling with accepting such a criterion, at least while practice is less than certain. So this criterion would in fact limit the freedom of states to choose their own form of government. If a state could only have a democratic government, it would then be required to have a democracy in effect, and this seems clearly to undermine the sovereign discretion of states to choose their own form of government. Which leads perhaps to the question of whether there's an alternative basis for identifying the government of a state. And at this point, I want to introduce a distinction between constitutional governments and unconstitutional governments. That is a distinction between a government which has a valid claim to power on the basis of the existing constitutional arrangement of the state, and a government which has no such claim. So once we adopt this distinction, it seems at least arguable that what practice shows is that constitutional governments, so those that have a valid claim to power on the basis of the existing constitution of a state, don't need to exercise effective control to be the government. And indeed, they are accorded preference over an unconstitutional government, even when the unconstitutional government possesses effective control. So not only does this explain the situations where democratic governments are accorded priority, and that's because the constitutions of the state dictate that the basis of the claim to power is to be a democratic election. It also explains why non-democratically elected governments are otherwise accepted. And indeed, if we look to the practice of recognition, including of the UK in respect of Guaidó, we see a reference to the constitutionality of the claim. So constitutionality, at the very least, does not appear to be wholly irrelevant to the question of governmental status. Now, that doesn't mean that identifying the government is always easy. And at this point, I want to sort of bring the discussion back to Venezuela. And that's exactly what the example shows us. So Guaidó claims to be the president on the basis of a particular reading of the Constitution of Venezuela, which provides that the president of the National Assembly is to be president when the incumbent becomes unavailable in certain circumstances. Now, to my understanding, it's unclear whether those circumstances cover the situation in which Guaidó has claimed the presidency, and that might indeed be one reason, at least, why there exists different or divergent practice in respect of the office of President of Venezuela. So just to conclude, there doesn't seem to be an apparent reason to dismiss the existence of an objective framework, even when states can't agree on who is the government in a specific case. There doesn't seem to be enough evidence to suggest a radical change such as that of democratic legitimacy. But all of this notwithstanding, it's not always easy to apply the criteria we may have. And indeed, how much of any of this is given weight within English courts, including to the UK government's recognition of Guaidó as the constitutional president, affects the decision as to who has access to Venezuela's gold, remains to be seen.
Terrific. Thank you very much, Nico. So all of this puts states in a very difficult position, it seems like, which leads us on very well to, I think, our next speaker. So our fourth and final speaker today is Professor Dr. Tom Ruys, who's a professor of international law at Ghent University, where he heads the Ghent Roland Jacquemin International Law Institute. He has a PhD from the University of Leuven, and he's a member of the Brussels Bar, and he's renowned as an expert in a range of fields of public international law, including the use of force and international dispute settlement. So his topic for today is on the prohibition of intervention in the internal affairs of other states and how this affects recognition of governments, whether recognition of the wrong president might itself be considered a breach of international law, as was indeed argued in the Court of Appeal. Tom, I look forward very much to hearing your remarks.
Thank you very much, Alex, for the kind introduction, and thanks again to you as well as to Nico and the UCL team for organizing this fascinating event. It's a pleasure to be here this evening. Well, as you say, the previous speakers have looked at depth in the distinction between de jure and de facto recognition in the court's judgment, at the various forms of recognition or non-recognition of either the Maduro or the Guaidó regime, and at the various factors that might regulate recognition under international law. Now, the purpose of my presentation is, well, it's a bit more modest. Let's say that the scope of the presentation is more limited in the sense that I will indeed focus on the question to what extent recognition of governments might lead to an infringement of the customary principle of non-intervention under international law. And I prepared a very short set of slides, just a handful of slides basically, but I thought it useful at least to show the relevant excerpts from the judgment, which I would like to focus on. Good. So for those of you, those in the audience that have read the judgments, you will know that at first instance, before the commercial court, the counsel for the Maduro board did argue that a recognition of the Guaidó regime as recognition of Guaidó as the interim president of Venezuela, that it might lead to a breach of the non-intervention principle. Now, the commercial court did not really engage with that argument since it was deemed to be irrelevant because the position taken by the FCO, by the Foreign Office, was sufficiently clear, and there was no need to interpret the scope of the recognition of the Guaidó regime by the Foreign Office. And so there was no need to look into international law, and accordingly, the non-intervention principle was left aside. Good. On then to the appeals judgment, which took a rather different approach altogether. Again, on appeal, the argument was made by the counsel for the Maduro board that the recognition of the Guaidó as the interim president, that it was contrary to international law, and specifically contrary to the non-intervention principle. And this is the key paragraph from the judgment that deals with this argument. And if you will read the provision, if you read the dictum, you will see that according to the court, there was a lack of authority to suggest that the recognition of a head of state or a head of government could be seen as contravening customary international law, specifically the customary rule of non-intervention. Okay. Now, when I read this passage in the judgment, I must say that I was slightly surprised. You will read that according to the court, Professor Saroushi was unable to cite any authority, domestic or international, to support his claim that there was a potential breach of customary international law. Okay? And the reasons for my surprise are manifold, in the sense that, of course, Professor Saroushi is a well-known scholar and practitioner, so one would expect that if there is any authority in support of the argument that there might be a breach of non-intervention, that he would be perfectly capable of unearthing that authority. A second point is that, well, it is a bit surprising to see the court refer to Oppenheim's international law in support of the position that there is no breach of the non-intervention principle, for the simple reason that Professor Saroushi, if I'm not mistaken, is one of the lead editors of the new edition of Oppenheim's international law. Good. Now, the more important point perhaps is what the court leaves out of the side from Oppenheim's international law on this slide. If you read the excerpt, the excerpt from the monograph says that, well, there are many acts which a state performs which touch the affairs of another state, such as the granting or withholding of recognition of a government. And these acts are deemed not to be forcible or dictatorial, and therefore do not come within the scope of the non-intervention principle. Now, interestingly, what the court leaves out of this side is the footnote. There is an interesting footnote, footnote 11, in Oppenheim's international law. And if you read that footnote, there is an interesting passage that says, and I quote, "But as to premature recognition, see paragraph 41. In other words, there is a cross-reference to another section within this, of course, enormously authoritative volume, which deals specifically with the question of premature or precipitate recognition, both of states and of governments, right? And if you look into the relevant excerpts from the other chapter in Oppenheim, there is indeed some evidence to the extent that indeed premature recognition, both of states and of governments, might well constitute a breach of the non-intervention principle. And so the idea that there is no authority in support of that position is somewhat surprising, in the sense that the very authority which the court cites does seem to be far more nuanced than this short provision from the judgment would seem to suggest. And indeed, there is further authority, at least in legal doctrine, that points at a potential breach of the principle of non-intervention. I'll give just a handful of examples. I have, for instance, Michael Wood in a piece on non-intervention, stating clearly that premature recognition of statehood is often seen as an unlawful intervention in the internal affairs of the territorial state. Then we have Stefan Talmon, who has already been cited by a number of speakers before me, who similarly argues that it has been widely accepted that premature recognition of an insurrectional movement as the government of a state amounts to unlawful intervention. Yeah? Similar positions can be found in Brearley's Law of Nations, or for instance in the Institut du Droit International's 2011 Wiesbaden resolution on intervention in civil wars. Good. So there are a number of authors that would appear to take a contrary view than what is laid out in this excerpt from the judgment. Admittedly, the position in legal doctrine is often rather ambiguous. There seem to be distinctions between, at least in some work, between recognition of states and recognitions of government, in the sense that with recognition of states, authors are at times more inclined to suggest that there might be a conflict with the non-intervention principle. Some authors would also seem to argue, or at least to state, more easily find a breach of non-intervention principle when there is a premature recognition of a government against the background of an ongoing non-international armed conflict, but there is at least some authority in conflict with this statement from the judgment. Specifically, when it comes to Venezuela, one document that I came across is a report by the Scientific Service of the German Parliament, which also says that there are strong reasons to assume that the recognition of a head of state ad interim in the present case constitutes interference in a country's internal affairs. And then the report goes on to say that it is perfectly legitimate to ask whether this particular interference, in the case of Venezuela, should be classed as inadmissible intervention. The question is, however, ultimately left open. Good. So authority, well, if you look at legal doctrine, the situation would seem to be far more nuanced than the judgment would appear to suggest. What then about state practice? Well, we've heard from Federica, of course, that state practice, and from Nico too, that state practice is blurred at times. At the same time, if one looks at, for instance, at the attitude of states vis-a-vis the situation in Libya in 2011, or vis-a-vis Syria in the context of the Syrian civil war, one can hardly ignore the fact that many states have been very reluctant to proceed to a recognition of opposition groups as the actual government, the de jure or de facto government of these countries concerned. And as Stefan Talmon has analyzed in great detail, oftentimes states have rather opted to rather confined themselves to a political rather than a legal recognition. That raises the question, of course, whether they are not guided in such conduct by a opinion juris, by a belief, a conviction that customary international law restricts the extent to which they can proceed to a recognition of a different government. So coming back to this passage from the judgment, the court suggests that there is a lack of authority, domestic or international. Presumably then the court construes authority as referring primarily to domestic and international case law, judicial practice in a way. And if that is indeed the understanding, one is presumably hard-pressed to identify domestic judgments that have indeed found practices of recognition to contravene the customary principle of non-intervention. At the same time, the lack of such authority may be due to, well, different reasons. There is the fact that in previous years, states oftentimes, well, generally refrain from proceeding to a recognition of government. There is, of course, also the fact that many national courts will simply not inquire into the executive conduct vis-à-vis recognition, that they will deem this to be excluded from judicial review because of the political question doctrine or any other domestic legal constructs. And so the lack of authority in domestic case law can hardly be conclusive in this context. So moving on, seeing it as there is a disagreement perhaps, or that there is conflicting evidence in legal doctrine and in practice, what guidance to use. And of course, when it comes to the principle of non-intervention, the main authority in this context is the famous Nicaragua judgment by the International Court of Justice, where in essence the court identifies two constitutive elements to identify or to determine the scope of the non-intervention principle. And firstly, as many will know, and there must be an interference in the state's domaine réservé, that is to say, a non-intervention presupposes that a state intervenes with another state's with issues on which the other state is supposedly free to decide freely. And clearly the choice of a state's political structure is widely seen as being the most obvious examples of what comes within the state's domain réservé. The second element then is the element of coercion, and the non-intervention principle is supposedly limited to coercive acts, but of course that begs the question what amounts to a coercive act or not. And in this context, one might say that, well, recognition of a government, it's simply a question of words, that from such recognition as such, no coercive impact can be distilled. And when, of course, we look at the practice of the ICJ, it is difficult to further clarify what the notion of coercive actually refers to. The only guidance that the court provides is two simple illustrations, in a sense that, according to the court, economic sanctions, economic boycotts will normally not be deemed to be coercive, whereas the funding of an insurgent group, an armed group within the state, is qualified as a breach of non-intervention principle. These two illustrations, these two examples do not make it much easier to conceptualize non-intervention principle and to understand what is meant with coercive acts, with the concept of coercion as such. And in legal doctrine as well, it is, authors have really struggled to come up with a convincing conceptual approach to the concept of coercion. Something that what must be looked at is the actual impact of the measures concerned. But of course, that partly puts the horse before the cart in the sense that it seems rather absurd to suggest that certain conflict would contravene the non-intervention principle if it succeeds in its stated objectives, whereas the same conduct would not amount to a breach of non-intervention principle if it is unsuccessful. Good. An interesting point that has been raised also in relation to the Venezuela gold judgment is that perhaps we ought to distinguish between the mere act of recognition and the subsequent conduct following a recognition. But of course, such a distinction is presumably difficult to make. one might rather believe that certain consequences follow automatically or maybe quasi-automatically from the mere act of recognition. And presumably the Venezuela judgment, Venezuela gold judgment illustrates such scenario in the sense that the act of, well, or the fact, the idea of receiving access to the Venezuelan gold was an automatic consequence in a way of the Foreign Office's decision to recognize Guaidó as the interim president. And so the supposed distinction between the mere act of recognition, which would be excluded from the scope of non-intervention principle, as opposed to the consequences resulting therefrom, seems to be something that is difficult to put into practice. And of course, a mere act of recognition may also have an impact on the legality of the acts that follow such recognition. And previous speakers have, well, mentioned to the example of potential intervention by invitation, which is the extreme example, of course. In legal doctrine, there is strong support for the idea that the de jure authorities are perfectly capable of inviting outside military intervention. And increasingly, legal doctrine suggests that they may even be the case when there is a civil war ongoing. Now, if that is true, of course, then the mere act of recognition would completely tilt the balance, would of course have an enormous impact on the application of the jus ad bellum as such. So that makes it difficult to separate the act of recognition from the consequences that follow. To continue, and I will maybe wrap up in a minute or two, maybe then it is, some would argue that it's perhaps impossible to come up with a convincing conceptual construction of what comes and what does not come within the non-intervention principle. And maybe then we have to acknowledge that in reality, the only approach is to accept that what amounts to a non-intervention, what amounts to an unlawful intervention is simply what authors, scholars, and states identify as such, what the majority position identifies as such. And you might say that maybe we should construe the content of the non-intervention principle similarly to the way we approach peremptory norms of customary international law and simply accept that it is the majority view that ultimately determines the content of the norm. The contrary position would be to maybe accept that the non-intervention principle, that it is perhaps devoid of any normative value, any autonomous normative value, and it is nothing but a rhetoric tool, an element that allows us to legitimize and delegitimize conduct in political discourse. However, I think that against this latter approach, caution is due. If we take the position that international law indeed regulates to what extent a state can recognize an entity as the government of a state, if we accept that there are certain criteria, whether those criteria be control over territory or rather democratic legitimacy, of course, then we also need a stick under international law to sanction the way in which states go about that practice. And what stick can there be ultimately other than the non-intervention principle? In other words, and that is my concluding point, I think we should be very careful before we throw overboard the non-intervention principle as a tool to control how states implement their recognition practice. And in that context, one may perhaps regret the approach taken by the Court of Appeals. Perhaps it would have been wiser to copy the approach taken in the US case pertaining to the Venezuelan state-owned oil company and to hide behind the political question doctrine rather than to put up for grabs the non-intervention principle. Thank you.
Terrific. Thank you very much, Tom. So we have some time for questions and discussion now, and we have a few questions that have come in already. So I want to kind of, I guess, group a couple of questions in together, and I'll direct this first of all at Peter, but I think it's sort of one that other people might want to come in on as well. So it's a question around the role of government statements in the English courts, the role of, if you like, executive determinations. So first of all, I guess to answer the question, what role do they play in English proceedings? Are they decisive, or is it open to the court to depart from them? But second of all, are we seeing a kind of movement away from the UK's sort of stated practice of not getting involved in questions of the recognition of foreign governments, and that policy that was announced in 1980, where recent practice perhaps seems to move away from that? And perhaps some comments from any of you on whether this is a good or a bad thing for executives to get more involved in these kinds of questions, given that it's very difficult for courts to navigate these questions. Is it better to leave these questions for governments rather than for judicial bodies? Or on the other hand, in the UK, it seems like we may also have a kind of failed executive determination given the ambiguous statements from the UK government. So does that not actually provide any help going forward? So Peter, if you wouldn't mind sort of going first.
Sure, thanks, Alex. So the first question, what role do executive determinations play? The answer to that is they're conclusive pursuant to the one voice doctrine. And that's one of the points for which the Court of Appeal decision is a very clear authority. The court retains the power to interpret exactly what the executive has said. But once it goes through that process of interpretation and determines, for example, that the executive has recognized Maduro as de jure interim president, there's no scope for the court then to reach any other conclusion. Has there been a move away? This is the second question. Has there been any move away from the government's abandonment of sort of recognition of governments in the 1980s? I think the answer to that has to be yes, and that recently there have been increasing instances of the government taking a position. Having said that, although the government moved away from making statements about recognition of governments, where an issue arises in as part and parcel of court litigation, it's very common practice to ask the government, the FCO, for its opinion on something. Third point, is it a good or bad thing for the executive to get more involved in this? I mean, views obviously will differ here. One of the points I didn't touch on in my presentation is that there's actually a split, I think, in the English case law about what the task of the courts is and the task of the government is in this type of situation. So there's a decision from Mr. Justice Hobhouse in the early 90s in which he said that after the government moved away from its policy of recognizing foreign governments, in fact, it turned to the courts to decide as a matter of fact who the government of the foreign state was. One of the more interesting points, I think, in the Court of Appeal's decision is obviously that approach is not being taken in this litigation. And as I say, views will differ as to which the better approach is, but mine, I think, is that these type of issues are so difficult to determine that it's almost obviously an issue that has to be determined by the executive as opposed to by the courts.
Does anyone else want to come in on that issue, or we've got other questions we can ask? No, okay. So a related question, which I think is one that anyone can come in on, really. How should the courts interpret? And this comes from one of the questions from our audience. How should the courts interpret recognition statements made by governments? What rules of interpretation should be applied to understand what a government means, particularly if you're looking at situations like in this particular case where there's some ambiguity around the statement that's been adopted. Perhaps I can direct this at Federica. Is the sort of diversity of practice that's out there illuminating in giving us clear lines about what statements do and do not constitute recognition and what they constitute recognition of? Or does that diversity of practice just reveal how difficult these questions are and how tough this is to navigate, particularly when states are sometimes adopting perhaps even a deliberate ambiguity about their approaches?
I think it's the latter. They just showed us how complex these things are. And in fact, they don't often use the term recognition in the same way. So the term recognition is used to mean different things. The terms de jure and de facto are used to mean different things. So it's always very difficult to just take the statements at face value and say, well, this is what this means. And I think that's one of the problems that the English courts have faced. The statement at face value seems really simple, but in fact, it hides a huge complexity behind it. So as a matter of international law, how do we interpret? Well, if the point of recognition, according to Brownlee, which I think is the right way of looking at this, is to identify the intention of the recognizing state, then you have to take the statement in the context in which it was made and against the background in which it was made. And so you would need to take into account other practice of the state as well. So I think that it is perhaps damning to some of those statements of recognition that Guaidó's representatives have not been recognized as ambassadors, whereas diplomatic relations have been maintained on the basis of, under the VCDR with Maduro. So you do need to take into account a whole host of things in order to try to understand what the governments actually mean and what the intention of those statements is, whether it is mere political support or if it is, in fact, recognition as a matter of international law. And I think Talman does note as well in some of his work that it can be an incremental process. It can be a gradual process. Something that begins as a statement of support, of political support, can slowly, end up as a recognition as a government, so recognition as something rather than just mere political support. And I think perhaps we just need to wait and see what these recognition statements actually will mean eventually, if more support, if they will be given the legal effect that a full recognition should have.
Did anyone else want to come in on those points? No, okay. I have a question for Tom, which really kind of follows on from the difficulties for states in dealing with a situation where there are two competing governments. So if international law takes the view that it's somehow wrongful to recognize the wrong government, if you like. So if you're dealing with a situation where there are two rival claims to power, and they're both claiming an entitlement under the Constitution, and there's a dispute, for example, whether elections were fair. So other states have no real way of knowing whether or not the elections were fair, right? They have no direct access to the evidence, to the information to back up their decision. So any act of recognition would seem to be an extremely risky one for states in those circumstances. So, I mean, is the answer that states shouldn't, that there should be a kind of period of absence of recognition, if you like, rather than a kind of positive or negative recognition, a kind of, well, non-recognition, but not in a negative sense, and in a kind of, a sense of an absence. On the other hand, does that risk weakening the legitimate government because they lose access to things like foreign assets, like the gold reserves of the country that might be held in a foreign state, or to they lose access to the support of foreign partners and international organizations who might help them to stabilize the situation in their country. So, what's the sort of the right approach here that states should adopt? I mean, should they be cautious about recognizing, or is that caution itself potentially problematic in some circumstances?
Well, thank you very much, Alex, for that question. It's not an easy one, of course. Let me maybe start with your reference to the constitutionality of regime change. And it's also something that Nico mentioned in his intervention, and to what extent should third states take into account whether the regime change or whether elections were organized in a proper way in line with the state's own constitution. Well, keep in mind the example of Ukraine, in 2014, when you had the Maidan protests, and you may recall that at the time President Yanukovych was ousted from power by the Ukrainian parliament. At the same time, there was a critique that this process was not fully in line with the Ukrainian constitution because of, because supposedly there were insufficient members present and they didn't have the sufficient quorum in the Ukrainian constitutional law to remove Yanukovych from power. And we know that the day after, when Yanukovych fled to Moscow, he did invite the Russian Federation to intervene militarily in the Crimean Peninsula. And so this really showcases the challenges that we're confronted with. It also shows that the constitutionality may be one element to consider, but again, it's not the final word, so to speak. And so I would indeed suggest caution. And to come back to your earlier question, whether we are increasingly seeing states applying recognition of governments in spite of their prior assertion that they would no longer be doing so. I do think that in recent years there has been this, this turn in state practice, that the famous Carrington statement from 1980, that it is no longer really fully reflective of reality. The question, of course, is whether what will happen after this episode is over, taking into account how the procedure will follow, what will happen in Venezuela. It may well be that this will be the high mark, again, of recognition of government practice, that maybe after this episode, states will come to the opinion that to avoid certain headaches, that it's better perhaps to confine themselves again to political recognitions only, and to accept that the incumbent regime, even if it lacks democratic legitimacy, is still to be treated as the spokesperson, as the state's representative, at least from an international law perspective.
Thank you very much. For a question to direct to Niko at this point, and I guess I'd like to hear Niko's thoughts on the de facto de jure distinction. So this is a distinction that seemed to be a little bit going maybe out of fashion in practice. Certainly, you know, the authorities on this distinction tend to be older cases in the English courts, and it seemed like this distinction was becoming a little bit obsolete, but it seems to be back in full force in the Court of Appeal's decision. And I guess my question is, do you think this distinction is a helpful one going forward? So what the distinction seems to promise is a way of separating out questions of legitimacy and effective control, rather than having to kind of combine those questions in a single test in a way that seems irreconcilable. So is it a helpful way forward for states and for courts to draw those kinds of distinctions so that they can ask these different questions separately? Or do you end up still with the kind of unresolvable questions about, you know, and I think Peter highlighted these in his presentation, what does it actually, you still have to answer the question, what does it actually mean to be the de jure or the de facto government? You know, what are the implications of that? And there you still have difficult questions to navigate. So Niko, I'd appreciate your thoughts on that.
Yeah, sure. Thanks for that question. I think the distinction has the potential to be useful, insofar as it can distinguish between a claimant which is the government as a matter of international law or as a matter of English law. You know, if we define that clearly, then we could have a position where a person or a group of persons is the government, and that would typically be de jure recognition. And then to have de facto recognition to refer to a liberation movement, an occupying power, anyone else, people working within who have sort of seized power in a coup, but who are not the government. So the distinction, I think, has the potential to be useful in order to distinguish those types of situations. So a person or a group of persons which is the government, and we know that they may be in exile, we know that they may be in control or whatever. On the one hand, and on the other hand, to have those who wield power over the territory and population, but may not, in fact, be the government. I think the reason why they're not particularly useful now, but rather can cause difficulties, is because the term de facto recognition, and Talman also discusses this in his book on the topic, where states use de facto recognition in all sorts of ways, including before English courts. We've seen the recognition of the Soviet government as a de facto government. And to my mind there, it seems to be simply a case of, we don't want to accept its legitimacy in some broader political sense, but we are accepting that it is the government. And so I think the distinction stops being useful when the terms stop being used consistently. And Federica also mentioned the point that they're used differently in different cases. And otherwise, they could be useful, as Peter mentioned. Also, there may be distinctions between English law as to who has access to what or for which purposes and so on. But insofar as these terms aren't used consistently, I don't think that they are especially useful anymore.
Great, thank you, Nico. Another question, which I'm going to draw from the questions from our audience. And I'm going to direct this one at Peter again, but I think this one's sort of open to anyone. Peter, in your presentation, you touched on this question of the need for this property to be held for the benefit of the people. And the question that we have from our audience relates to this, the fact that withholding the gold from a particular government would potentially have the risk of preventing that government from assisting its citizens. From using that for the benefit, and I think the Maduro government, for example, has argued that that it needs the receipts from these gold sales to deal with the COVID crisis, for example. That's one of the sort of points that's been raised. And I guess the question is, what role are there in what are the kind of principles of international law that might also have an impact here? Particularly on other states' refusal to engage with questions of recognition. I mean, does this suggest an approach that's more weighted in favor of de facto control? Because the authority that is in effective control of the territory is better able to distribute that money? Or does it suggest a focus on legitimacy and the question of whether the money, of whether the proceeds of the sale of gold would actually be used for the benefit of the people? Is it really an authority acting as a representative of the people? So direct that first at Peter, because that was a point that I think came up in your presentation. But if anyone else wants to come in, please do.
Thanks, or I say thanks, but it's a very difficult question, I suppose. I mean, I think almost you've exposed the two different arguments when setting out your question. If one has a regime which is in effective control, then it can advance a very serious argument that it really is the only party which is, for the time being, legitimately able to use the assets for the benefit of the people whom they're intended to serve. And it says an awful lot, I think, for a state to refuse that regime access to them. The issue, I suppose, becomes if one assumes that regime is going only to be in place for a very short period of time, or if there's some doubt about its permanency. And if there is, then it becomes possibly more objectionable that it can gain access to it can trigger something which has such sort of permanent and irreversible consequences on the state's assets.
If I may.
Yes, please, Tom.
Well, maybe to link your question to the my own point I tried to make on the non-intervention principle. As I mentioned before, according to the ICJ in Nicaragua case, a state breaches non-intervention principle when it gives funding to an insurgent group in another country. But if we believe if you follow the line of reasoning in the Court of Appeals judgment, and there will be no breach of non-intervention principle if you simply recognize an insurgent group and give them the keys to the state's bank accounts, so to speak. Now, there is, of course, another interesting element here in the sense that, again, referring to the Nicaragua judgment, the court acknowledges that, humanitarian assistance, in a way, can never amount to a breach of non-intervention principle. And you might, argue that in as much as access given to a bank account with a view to alleviating human suffering, to providing for medical care and what have you, that indeed that would remedy any potential conflict with the non-intervention principle. The question, of course, remains how would you put that into practice? Would it entail that the state concerned, in this case the UK, would have to in one way or other verify how the bank accounts are being used, or that the bank itself ought to set up some monitoring system? That would be highly interesting, of course, and it might be something worth exploring in reality.
Just to follow up on that point, if I may, this is exactly what has happened in the US. So the US has unfrozen certain funds that belong to the Venezuelan state and given access to those funds to Guaidó. And since then, they have used it to pay sort of bonuses and stipends to Venezuelan doctors attending to the COVID situation. So 3 payments have been made, one of $100 each for the last 3 months. So I don't know what the logistics have been, but that has actually happened in practice, which in a way goes to show that you don't actually need to be in physical control of the territory to do these things. So there.
Great, thank you. One final question, I think, for Nico, again from our audience. And the question is about the role of constitutionality as a criteria in a situation where both entities have competing and conflicting readings of the same constitution. So should that criteria still play a role in that situation? How should international law identify whose reading of the constitution is correct, or should it not have an answer to that question? Should it not be engaging with that question? Should there be deference to the courts of that legal system itself, or is it open to foreign courts to reach their own determination as to the correct interpretation of another state's constitution in those circumstances? Nico.
Thanks. I think that's an excellent question and not an easy one, I don't think. I would say it depends. So where there is agreement within the state as to the constitutionality of a claim and all state organs are on board, then there seems to be little difficulty or trouble or question about accepting that interpretation. So when Edward Bennis made the claim to being the president of Czechoslovakia, I think in '42, really a questionable claim on the basis of the constitution, but seems to have been accepted by states because no one really opposed it. Where it's opposed and we have some arguably objective or at least external verification. So in the case of Côte d'Ivoire, for example, we had verification and certification of results by a UN organ that was monitoring the elections. That seems to have been decisive in practice, and states seems to have waited for that and then responded to that certification, because there, I can't remember the details, but there were definitely differences between different state organs, and indeed the incumbent president saying one thing and the person who came into office eventually claiming a different thing. Where there's no agreement domestically and where there's no external authoritative, if you want to put it that way, determination, and of course it's not legally authoritative, sort of what the UN election mission might say, but at least external and seen as perhaps as impartial. That's where the tricky situations are, as with Venezuela. And I want to bring up the example that Tom mentioned as well, because I think that's actually quite similar to the case in Venezuela, in the sense that the parliament in Ukraine and in Venezuela, respectively, each have acted in a way which is not necessarily clearly in accordance with the constitution of the respective state. In Ukraine, there seemed to have been virtual agreement, bar Russia, that Yanukovych was no longer the president. The Council of Europe seemed to have said that what the parliament did was in accordance with constitutional principles or reflected constitutional principles, or a statement to that sort of effect. But obviously we don't have any such agreement in Venezuela. So I don't think the domestic bodies are determinative when they themselves disagree. I don't think any external state is determinative either, but what they do might provide us with evidence as to what the correct answer is.
Great, thank you very much. I am afraid that's all the time we have for this event. I want to say thank you again to all our panelists for your terrific presentations. So thank you, Peter, Federica, Nico, and Tom. And thank you to our audience for being with us. Thank you everyone for your attention, and have a nice evening.